Dear viewers, warm greetings from my side. I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law. We all know negligence is an omission to do something that ought to have been done or an act of commission that ought not to have been done. In order to understand the essential ingredients of the tort of negligence, it is imperative to shed some light on the two rival theories about the nature and definition of negligence. According to the subjective theory propounded by Austin, negligence is a faulty mental condition that is penalized by the award of damages. Salmon further says that negligence is culpable carelessness. Listeners, according to the second theory, which is the objective theory, negligence is not a particular state of mind or a form of mens rea at all, but a particular kind of conduct. It is interesting to note that in support of this theory, it was stated that negligence is the opposite of diligence and no one describes diligence as a state of mind. In this situation, it makes more sense to talk about what Elderson said in the case of Blythe versus Birmingham Water Works. He said that negligence is either not doing something that a sensible person, based on the rules that normally govern how people act in society, would do, or doing something that a sensible person would not do. Now we shall ponder upon the essential conditions or ingredients of the tort of negligence. Viewers, there is a case called Heaven versus Pender that is relevant for the current discussion. In that case, it was decided that actionable negligence means failing to use ordinary care or skill towards a person that the defendant is supposed to use, but he fails to do that and the plaintiff has, on account of the neglect, suffered some harm or damages. So we can say that where there is no duty, there can be no action for negligence. In the case of Viren versus T.V. Krishnamurthy, it was rightly observed that negligence involves three ingredients: a legal duty to take care, breach of that duty, and consequential damage to another. From this case and other judicial pronouncements, we can infer that the cause of action for negligence arises only when damages occur. The claimant has to satisfy the court on evidence that the following three grounds are present. First of all, the duty to take care. Secondly, failure to maintain that standard of care. And thirdly, damage suffered on account of the breach of the duty. Listeners, we all know that rights and duties are the two sides of the same coin. With reference to the tort of negligence, it is imperative that the duty in question be a legal duty rather than a mere moral, religious, or social one. Whether the defendant owes a duty to the plaintiff or not depends on the reasonable foreseeability of the injury to the plaintiff. If at the time of the act or omission, the defendant could reasonably foresee injury to the plaintiff, he has a duty to prevent that injury, and failure to do makes him liable. Here, the plaintiff has to establish that the defendant owed him a specific legal duty to take care of which he has made a breach. Dear viewers, the landmark case in reference to the first essential, which is the duty to take care, is the case of Dongo versus Stevenson. The brief facts of this case are that the plaintiff purchased a bottle of ginger beer from a retailer for the appellant, a lady friend. Some of the contents were poured into a tumbler and she consumed them. The remaining contents of the bottle were put into the tumbler and the decomposed body of a snail floated on it with the ginger beer. The appellant alleged that she seriously suffered in her health as a consequence of having drunk a part of the contaminated content. The bottle's metal cap and dark opaque glass construction prevented visual inspection of the contents. She brought an action against the manufacturers for damages. One of the defenses pleaded by the defendant was that he did not owe any duty of care to the plaintiff. The House of Lords held that the manufacturer owed her a duty to take care that the bottle did not contain any noxious matter and that he would be liable for the breach of that duty. According to the House of Lords, the manufacturer owed a duty to her, that is, the claimant, to take care and make sure that the bottle did not contain contaminated beer. Since he failed to exercise due care in this case, there was a breach of duty on his part, which made him liable for damages to the plaintiff. Another defense pleaded by the defendant was that the plaintiff was a stranger to the contract and her action was therefore not maintainable. Lord Atkins said, "It is remarkable how difficult it is to find in the English authorities statements of general application defining the relations between the parties that give rise to the duty. The courts are concerned with the actual relationships that come before them in actual litigation, and it is sufficient to say whether the duty exists in those circumstances. The result is that the courts have engaged in an elaborate classification of duties as they exist in respect of property, whether real or personal, with further divisions as to ownership, occupation, control, and distinction is based on the particular relations of one side over the other, whether manufacturer, salesman, or landlord, customer, tenant, stranger, and so on. In this way, it can be ascertained at any time whether the law recognizes a duty, but only where the case can be referred to some particular species that has been examined and classified. The duty to take care arises out of various relationships, which it may not be possible to eliminate exhaustively and recognize new duties when they think that to be just. Lord Macmillan stated that categories of negligence are never closed. Here it is significant to note that Lord Atkins propounded the following rule in this case. The rule is that you must take reasonable care to avoid acts or omissions that you can reasonably foresee would be likely to injure your neighbor. He then defined neighbors as people so closely and directly affected by my act that I could reasonably have them in contemplation as being so affected when I am directing my mind to the actual omissions that are called in question. So, viewers, we have to keep one thing in mind. To bring a case under negligence, the defendant was under a legal duty to exercise due care and skill, as there cannot be any liability for negligence unless there is a breach of some legal duty. And the duty must be towards the plaintiff. In the case of Thomas versus Quatermain, it was observed that the idea of negligence and duty are correlated, as there is no such thing as negligence in the abstract. Negligence is simply the neglect of some care that a person is bound to exercise towards somebody. Also, You cannot sue someone for negligence related harm unless they had a duty to be careful. This duty could be a normal common law duty, a duty made by law, or a duty created by a private act. In this regard, a reference can be made to Lord Atkin in Dongo versus Stevenson, which laid down the principle of neighborhood, which helps to decide if, in a particular case, the duty of care exists. His Lordship said, "You must take reasonable care to avoid acts or omissions that you can reasonably foresee would be likely to injure your neighbor." He further said that it is remarkable how difficult it is to find in the English authority statements of general application defining the relation between parties that give rise to a duty. The courts are concerned with actual relationships that come before them in actual litigation, and it is sufficient to say whether the duty exists in those circumstances or not. Dear listeners, with the passage of time, it was felt that the neighborhood formula may not be suitable in all circumstances as new forms of negligence were arising. Thus, in the case of Home Office versus Dorset Yacht Company, new positions emerged. In the case of Annes versus Meriton London Borough, the House of Lords concurred as follows. Now it is thought that to prove that there is a duty of care in a certain situation, the facts of that situation do not have to be similar to those of other situations where a duty of care was found to exist. Rather, the question has to be approached in two stages. First, one has to ask whether between the alleged wrongdoer and the person who has suffered damage, there is a sufficient relationship of proximity or neighborhood such that in that reasonable contemplation of the former, carelessness on his part may be likely to cause damage to the later, in which case a prima facie duty of care arises. Secondly, if the first question is answered affirmatively, it is necessary to consider whether there are any considerations that ought to be negative, or to reduce or limit the scope of the duty, the class of persons to whom it is owned, or the damages to which a breach of it may give rise. In the next limb of the discussion, we shall discuss whether the defendant owes a duty to the plaintiff or not, depending on the reasonable forcibility of the injury to the plaintiff. If at the time of the act or omission, the defendant could reasonably foresee injury to the plaintiff, he owes a duty to prevent that injury, and failure to do so makes him liable. In the case of Veeran versus Krishnamurthy, 1966, the court rightly said that to decide culpability, we have to determine what a reasonable man would have foreseen and thus form an idea of how he would have behaved under the circumstances. In the 1973 case of Mysore State Road Transport Corporation versus Albert Dias, the court said that one good way to figure out how careful someone should be in a given situation is to ask how obvious the risk must have been to a normally cautious person. Here it is significant to refer back to Lord Macmillan in the landmark case of Glasgow Corporation versus Muir, 1943, in which the following observation was made. The standard of foresight of a reasonable man is, in one sense, an impersonal test. It eliminates the personal equation and is independent of the idiosyncrasies of the particular person whose conduct is in question. Some people are, by nature, usually timorous and imagine every path beset with lions. Others, of a more robust temperament, fail to foresee or disregard even the most obvious dangers. The reasonable man is presumed to be free both from over apprehension and from overconfidence, but there is a sense in which the standard of care of the reasonable man involves, in this application, a subjective element. It is still left to the judges to decide what, in the circumstances of the particular case, the reasonable man would have had in contemplation and what accordingly the party sought to be made liable ought to have foreseen. Dear viewers, here there is a room for a diversity of views. What one judge may seem far-fetched, to another may be both natural and probable. In the case of MP State Electricity Board versus Ramlal Vishwakarma, 2013, a child of 10 years died due to electrocution by coming in contact with a live naked wire embedded with an electric pole while current was flowing in it. Stating that the defendants were duty bound to examine and check from time to time whether any current was running in the said wire, so that any person or even a cattle might not face the hazardous situation, the MP High Court held the defendant liable to pay compensation to the plaintiff, the father of the deceased child, since they were negligent in performing their duty. The court said that negligence is breaking a duty by not doing something that a sensible man, based on the things that are normally guiding people acting in public, would do, or doing something that a sensible and prudent man would not do. In the case of Ishwar Devi versus Union of India, 1969, one Shamlal Malik, the deceased, boarded a DTU bus when the same arrived at the bus stop. Just when he had placed his foot on the footboard of the bus and had not yet gone in, the conductor, in a very great haste, rang the bell and the driver started the bus. The driver made an attempt to overtake another stationary bus closely, and the deceased got squeezed between the two buses and sustained serious injuries, which ultimately resulted in his death. In an action by the widow of the deceased, it was held that both the driver and the conductor were negligent in not taking proper care of the safety of the passengers. It was observed that the safety of the public who travel by public convenience, like the bus in question, is the primary duty of the conductor and the driver, who are in charge of and control of the public conveniences. When the conductor saw that the deceased Shamlal was boarding the bus and was still on the footboard, he should not have given the bell for the start of the bus, but should have waited till Shamlal got inside the bus. To have given the bell and the signal to the driver to start the bus is nothing but rashness and negligence on the part of the conductor. The conduct of the driver was also rash and negligent in that he drove the offending bus so closely near the stationary bus that there was no sufficient clearance between the two buses, and the deceased got squeezed or sandwiched between the two buses. Moving forward, in the next part of the discussion, we shall focus on no liability when the injury is not foreseeable. Dear viewers, in the case of Cates versus Mongini brothers, 1917, the plaintiff, a female customer at the restaurant, suffered injuries as a result of a ceiling fan falling on her. The reason for the fan falling was a latent defect in the metal of the suspension rod of the fan. A reasonable man would not have been able to find the flaw. In an action against the defendants who were running the restaurant, it was held that since the harm was not foreseeable, they were not negligent and therefore they were not liable for the loss to the lady plaintiff. Moving forward, in the case of Krishnappa Naidu versus Union of India, 1975, the defendant railway train struck the plaintiff taxi as it was passing through a level crossing. It was found that the taxi driver entered the level crossing in spite of the warnings given by the gateman. The taxi driver was therefore negligent in his act on the railway track, whose presence could not be anticipated by the railway driver. The accident could not be averted in spite of the best efforts of the railway administration. Since there was no negligence on the part of the railway administration or its staff, the defendants were held not liable. Moving forward, dear viewers, reasonable forcibility does not mean remote possibility. To establish negligence, it is not enough to prove that the injury was foreseeable. A reasonable likelihood of the injury has to be shown because foreseeability does not include any idea of likelihood at all. The duty in this regard is to guard against probabilities rather than bare possibilities. In the case of Faradin versus Harcourt Rivington, 1932, the defendant parked his car by the roadside and left a dog inside the car. The dog jumped about and smashed a glass panel. A splinter from this glass injured the plaintiff while he was walking past the car. It was held that, being very unlikely, there was no negligence in not taking a precaution against it, and therefore the defendant was not made liable. Lord Dunedin said that if the possibility of danger emerging is only a mere possibility that would never occur to the mind of a reasonable man, then there is no negligence in not having taken extraordinary precautions. People must guard against reasonable probabilities, but they are not bound to guard against bare possibilities. In the end, we can conclude by saying that negligence is an omission to do something that ought to have been done, or an act of commission that could not have been done in law. It is also felt that the idea of negligence and the duty to take care are correlated, as there is no such thing as negligence in the abstract. The liability of the defendant shall arise only when he or she has a duty to take care, and no action exists for the harm caused by negligence unless this duty exists. With this, we come to an end of today's lecture. Thank you very much.